You want me to share your piece of paper?
No. Oh, you know what? Don't rush me. Try it with basketball. No, I don't like it. I'm scared.
Court, all rise.
Hi, Taisha.
Please proceed to go to town session. Turn up your cell phones, please.
Afternoon. We are on the record on Commonwealth vs. Karen Reed on docket 22 CR 117. Beginning with the prosecution, can we have the parties introduce themselves?
Good afternoon, Your Honor. Laura McLaughlin for the Commonwealth.
Good afternoon, Ms. McLaughlin.
Good afternoon, Your Honor. Alan Jackson on behalf of Ms. Reed.
Good afternoon, Mr. Jackson.
Good afternoon, Your Honor. Elizabeth Little.
Good
Also
afternoon.
on behalf of Ms. Reed.
Good afternoon, Ms. Little.
Good afternoon, Your Honor. David Unetti for Karen Reed.
Good afternoon, Mr. Yannetti. Good afternoon, Ms. Reed. Okay. Oh, all right. So here comes Mr. Lally. Were you expecting him, Ms. McLaughlin?
Yes, Your Honor.
All right. I'm sorry. I would not have started. All right. So, Mr. Lally, if you just say your name for FTR to
Yes,
get
sure.
out.
I'm Lally for the Commonwealth. Good
All
afternoon.
right, good afternoon, Mr. Lally. Okay, so when we were all last in court on February 15th, There was obviously Mr. Lally, why don't you have a seat? A joint motion to continue the motion to dismiss and the motion for sanctions and disqualification, and have those heard on March 12th. So at the time, as you all remember, I said it was premature. So now we are in receipt of your motion to continue because of recent developments. So I'm also mindful, I did just this morning receive a letter from the Deputy U.S. Attorney, and she made it clear that the parties can make oral references to the contents and the materials and proceedings in this courtroom. But she also cautions that only is necessary to further the proceedings. So in light of that caution, I obviously have not seen and have no idea what these materials are. In light of that caution, what I'd like to do is set some dates. I do agree that we can hear that motion to dismiss and motion for sanctions and disqualification. So I'd like the parties to, it says you received the information from the U.S. Attorney's Office on February 21st, and I know you outline in your motion that it's very voluminous.
That's correct.
All right.
The evening of the 21st, we basically have had access to it starting on the 22nd until today.
Okay, so that's why I'm going to give you until March 6th to file any supplemental memo or motion on those 2 points, on the motion to dismiss and motion for sanctions. So the defense has until March 6th to file any supplemental motions and memos on those two. The DA has until March 11th to respond. And on March 12th, we'll have a hearing on those motions.
Your Honor, if I may be heard.
I have more of a scheduling order, and then I'll hear you.
I
Okay?
just want to be heard on the scheduling before we move off to that topic, so thank you.
Yep, no, this is all the dates that we're moving. You move to continue, and these are the dates we're having. Do you want me to say them again, Mr. Jackson? No. So on March 22nd, all motions in limine must be filed. On March 28th, at 9 o'clock in the morning, we'll have a hearing on those motions in limine. On April 12th, there'll be a final trial conference at 9 a.m. And on April 16th, the jury trial will begin. So it's a 5-week continuance of this jury trial. So I'll hear you.
I appreciate that, Your Honor. Thank you for hearing me on the issue of scheduling. I just want to bring to the court's attention a couple of things. I appreciate the court accommodating us in terms of the motion to dismiss today. I was prepared to argue the motion to continue on that issue, unprepared to argue substantively the motion to dismiss.
We're not.
I understand that, but for the following reason. We received 3,074 pages, 1.3 gigabytes of data. We've only had a chance to go through a smattering of that data so far, right? Okay. So a couple of transcripts, we've reviewed and looked at or put our eyeballs on the files, but not the substantive data contained within those files. And I would dare say that the Commonwealth is in the exact same position. There has been an additional TUI request by the Commonwealth that the court is probably not aware of. That came in on Friday. Ms. McLaughlin asked the U.S. Attorney's Office, pursuant to TUI, which is exactly the same protocol that we utilized to get these almost 3,100 pages of data. And so we're expecting that to be heard at some point through the U.S. Attorney's system. In other words, they're going to have to go to the magistrate, deal with the TUI system the same way that it took place here. And that takes not days, but weeks, I expect. We also haven't finished the Bodhi protocol, which is the state's protocol with the crime lab that you're well aware of. I say that to say, through 2 years of litigation with the Commonwealth, just about 2 years of litigation, we've received a little over 3,200 pages of data. In one day, the defense was given 3,100 pages of data, and none of it appears to be duplicative. All of it is brand new, and all of it, Your Honor, appears to us to be exculpatory. The schedule that the court has suggested, although I'm mindful of moving this along, I I can't do it in violation of my client's due process rights. I can tell the court there is no possible way that we'll be ready for, just to grab my notes, there will be no possible way that we could have all of our motions written on this issue alone, just the motion to dismiss, by March 6th. That's
So
it's just too big.
what I need you to do is put in writing why.
Sure.
All
Sure.
right?
I can tell.
I am very mindful, though, where the U.S. Attorney says we expect, of course, that the parties will disclose orally the materials in court only as necessary to further the proceedings. So put something in writing, get it to me by this time next week as to why you cannot be ready specifically. But I'd urge you to use that time getting ready. All right?
May I have just a moment to confer with
Yes.
counsel? Your Honor, thank you for accommodating that quick chat. I want to make sure that the court understands that in addition to, and that's what Mr. Yannetti was just urging me to bring to the court's attention, I don't want to speak for him, he can speak for himself. There is a motion to disqualify, which is also robust in scope and terms. He's going to be arguing that. That is yet to be on calendar, and he just indicated to me he does not believe there's any way that he could be ready on this briefing schedule for this kind of influx and incorporation of this level of data.
So
There's
you
going to be.
can put that in writing as well, Mr. Yannetti.
That's fine.
I just want to put a sort of a precursor to the court. We expect additional rules based on what we've got so far, and I'm happy to describe a sampling of it if the court wishes. But based on what we've gotten so far over the last 48 business hours or so, there's going to be additional Rule 17 motions, significant additional Rule 17 motions. There's going to be additional Rule 14 motions. We're going to have to supplement the motion for disqualification that Mr. Yannetti just alluded to. We're going to need to supplement the motion to dismiss, which I'm alluding to. We will be filing a motion for extraordinary governmental misconduct based on certain evidence that we just received. And all of this has to predate any reasonable effort that we have to prepare for trial. So my suggestion, and we'll put it all in writing, as the court suggested, but I can tell the court that based on what I know, and I know that the court is operating a little bit in the blind, because you don't know what we know, what we have. An April 16 jury trial date is probably not realistic, but I will put all of that, as the court has directed me to, we'll put all of that in writing, and we will suggest what we think is a reasonable trial schedule and briefing schedule based on what we've just received.
Okay, so I need that by next Monday at the latest, okay? Ms. McLaughlin.
A week from today, yes.
Your Honor, if I may, the Commonwealth has had the opportunity to go through all the discovery that's been provided. It is voluminous. It is, there's a lot of material there. However, the Commonwealth would dispute counsel's representation that the material is new information. I would say approximately 90% to 95% of the material that we received is consistent with the Commonwealth's theory of the case and the testimony that went to the grand jury of witnesses' statements. There is some new information that counsel will use in their motion, and the Commonwealth understands that. However, I would say the evidence as a whole is very consistent with prior statements made by witnesses that testified for the Commonwealth. Thank you.
All right. All right, so put it in an affidavit by next Monday, but these days, as of now, these are our dates. Okay?
I want to make sure I got the dates, all the dates that the court indicated. March 6th for the motion to dismiss.
To file any supplemental memos on the motion to dismiss and the motion for sanctions, disqualification of the district attorney's office.
The next date, March 22, for motions, all motions in limine.
Yes,
March 20
for filing all motions.
March 28 for hearing on all motions in limine.
Yes.
April 12, last readiness conference at
Yeah.
9 a.m.
Yes,
And April 16 for jury trial.
yes. Okay,
Your Honor, if I may, I may not have heard. The March 12th date, was that 9 a.m. or 2 p.m.?
March 12th, we can go at 9 o'clock and we can take all day. So, all right?
Your Honor, what are the dates for the Rule 17s that we anticipate filing, which we expect are going to be voluminous?
Why don't we do those on March 12th as well?
Okay, Your Honor, we have the calendar that the court has suggested, and we'll file our papers by Monday.
Great. We'll see you on the 12th. Thank you. All right. You want a short recess?
All rise.
Goodbye.
All these.
I have a quick question. So, if I'm here Mondays and Fridays, and so I think that the jury trial is going to be on Tuesday. When I'm not scheduled for my internship, can I still sit right now? Okay, I was just going to use.
Yeah, no, anytime.
All right.
Of course.
Tried to teach me. I've come a long way. I got a ways to go.
It'll happen at some point. We know that.
But she told me to reiterate.
That's not
Thank you very, very much.
should honestly just mind my own business. That's it. Okay. All right. Thank you.
It's like I feel like setting up something. We did the hearing show you and everything is fine, so rest up. Rest up, Buttercup.
I'm always at peace when the Tories up here.
Good, I am glad, Brian.
Beth?
How are you? Hi. Tomorrow. Yeah, it better be. Right, Brian?
You have a little jury wave thing in the way.
Much longer.
It's gonna finish.
Yeah.
I just want to let you know, this is Flash, and I have to crawl underneath and fix it, but I didn't want to do it before that hearing. So just can't mute, just so you know. You can speak, and it will
Okay,
pick you
and
up.
it'll pick me up. I just shouldn't say anything.
Shouldn't say anything you don't. On the record.
April 29, Monday.